India is a vast federation, a collection of states with diverse laws, languages, and cultures. Yet it manages this immense geographical and legal complexity through one single unified chain of justice. How does this colossal integrated system, stretching from the Supreme Court right down to the local courtrooms, actually manage that dual mandate of enforcing both federal and state laws simultaneously? It's more than just a theoretical concept. It's a constitutional marvel adopted directly from the Government of India Act of 1935, a structural decision that defined the nature of our quasi-federal state.
It is truly a marvel, and the key to its stability lies not merely at the apex of the pyramid, the Supreme Court, but in the meticulous legal foundation of the courts that directly impact the everyday citizen, the subordinate judiciary.
The ones on the ground level.
Exactly. That bottom tier requires immense coordination and critically specific constitutional safeguards, predominantly housed in Part 6 of the Constitution, to prevent the system from dissolving into administrative and political fragmentation at the state level. That is fundamentally where the unified structure hits the ground running.
Welcome, you deep dive learners, to the show designed to give you the most concise yet thorough and analytical understanding of complex governance structures. We are specifically tailoring this deep dive for the rigorous preparation required for competitive examinations like the UPSC, ensuring that you move beyond more memorization to critical synthesis. You've shared your sources, and our mission today is, well, it's crystal clear. We are breaking down the foundational machinery of justice below the high courts. Before we jump into the core of Part 6 of the Constitution, let me take a crucial moment to address the community. We humbly request you, if you are capable and find this content super useful for your preparation, to please subscribe to the channel right now and join our paid membership.
It really does make a huge difference.
It's absolutely critical. It enables the continuous creation of this high-quality, meticulously researched, deep-dive content that helps thousands of students prepare efficiently, just like you. And a heartfelt shout-out must go to all our existing members. Your consistent backing is precisely what makes this work possible every single week. Please remember to hit that like button right now and, crucially, share your valuable comment below. Tell us what constitutional topics, perhaps in relation to governance or social justice, you want us to tackle next.
And on that note of preparation, today's topic, focusing on the judiciary below the high court, is absolutely foundational. I can't stress this enough. Mastering this specific mechanism is the bedrock for answering truly diverse and high-level mains questions.
It's not just about knowing the courts, it's about connecting them to policy, right?
Precisely. Consider the range of topics you face in the examination, linking the enforcement arm of the state to policy. From discussing the viability and legal challenges of the food security bill regarding WTO obligations, to analyzing the non-implementation of constitutional mandates like the Fifth Schedule in areas affected by left-wing extremism, or understanding the impact of liberalization on the enforcement of commercial contracts.
Wow, okay.
All of these high-level policy discussions, which feature heavily in previous year questions, rest fundamentally on the administrative and judicial structures that enforce them. I mean, if the subordinate courts are weak, the policy framework collapses.
Exactly. Knowing the nuts and bolts of the judicial machine, how a district judge is appointed, how specialized tribunals function, allows you not only to describe what governance is, but to fundamentally critique how well it is delivered. That institutional weakness or strength is what separates a factual answer from a high-scoring analytical one.
And for all of you pursuing the UPSC exams, a quick but important notification. We have free notes covering this entire discussion, complete with practice, previous year questions, or PYQs, available right now on our Telegram channel.
And for our legend YouTube members, we have something extra.
Yes, for them, we have premium notes offering extra PYQs and detailed model mains answers for complex mains questions accessible via our Discord channel. Do join these communities. They are vital resources to maximize your preparation and application of this knowledge.
Okay, let's unpack this. Our specific mission today is to move beyond the Supreme Court and high courts. We're going to thoroughly break down the entire structure of the judicial system beneath the high courts, focusing keenly on how judicial personnel are appointed.
And then we'll pivot.
And then pivoting to how specialized, yet interconnected, bodies like administrative tribunals and alternative dispute resolution systems function. We'll be drawing connections directly from the Constitution's Part 6, Chapter 6, specifically Articles 233 through 237, and then connecting those constitutional anchors to the modern complementary statutory bodies.
What's fascinating here is the sheer ingenuity of the system's design. The Indian Constitution consciously integrates judicial authority. Unlike the dual court system seen in the United States, where state courts handle state laws and federal courts handle federal laws.
Which seems like the more obvious federal approach.
It does. But India adopted a unitary judiciary despite maintaining a federal distribution of legislative and executive powers. This integrated hierarchy is a key feature of our quasi-federal structure and ensures that central laws and state laws are enforced uniformly through the same chain of command, a structural mandate for national unity.
Let's start with that foundational concept then, the integrated judicial system. We often hear this phrase, but what does it mean in practice? And why did the framers choose this structure over a dual system? It was, after all, a conscious choice adopted from the Government of India Act of 1935.
That's a critical question. When we say integrated, we mean that the entire judicial apparatus, from the Supreme Court at the top down to the high courts and then the subordinate courts, forms a single, seamless pyramid. Jurisdiction flows downwards and appeals flow upwards through a common structure.
So no separate court systems for separate sets of laws?
None. The key functional aspect is that this single system enforces both central laws enacted by Parliament and state laws enacted by the state legislatures. That's the core of it.
And that stands in stark contrast to the U.S. model, which is often cited as the archetype of pure federalism. In the USA, if you have a state contract dispute, you go to a state court, and if you have a federal intellectual property dispute, you go to a federal court. They maintain separate systems with different jurisdictional scopes, which can sometimes lead to friction.
Precisely. And if we connect this to the bigger picture, this unified structure is indispensable for maintaining legal uniformity and coherence across a large, diverse country. India is a union of states, as defined in Article 1, and the integrated judiciary acts as a critical institutional bulwark reinforcing that union.
So it's a unifying force.
A powerful one. Without a single judicial system interpreting the same laws consistently, you could easily see legal interpretations wildly diverging between states, a situation that would destabilize commerce, civil rights, and national governance. This unity is further reinforced by other unitary features, such as the single citizenship provision and the All India services, all working towards systemic consistency.
So the judiciary is a centralizing force in our quasi-federal system. Now let's find its constitutional home. When we look at the structure of governance, these subordinate courts seem to operate locally, under state control, even though they enforce central law. Where do they sit constitutionally?
They are structurally positioned under the state administration. This is a crucial detail for UPSC aspirants. Because the personnel, facilities, and funding for these courts are primarily the responsibility of the state, they are laid out in Part 6 of the Constitution, titled The States.
Okay, so they're part of the state machinery.
Yes. And within this massive section, we find Chapter 6, which is dedicated entirely to the subordinate courts.
That placement is deeply revealing of the constitutional design. Chapter 6 covers Articles 233 to 237. These 5 articles are the legal foundation that defines the lowest rung of the formal judicial hierarchy, operating directly under the administrative and supervisory control of the High Court.
And this raises an important question. Although the Supreme Court and High Courts are fiercely independent, the constitutional mandate places the operational aspects of the subordinate judiciary firmly within the framework of state governance. This tension is where the administrative challenge lies.
The state executive controls the purse strings.
Exactly. They control the purse strings and provide the physical infrastructure and staff, yet the High Court must wield judicial control and independence through its oversight powers. The framers intentionally separated resource allocation, which is the state executive, from judicial supervision, which is the High Court.
Speaking of judicial supervision, let's dive into the core mechanism ensuring judicial quality at the district judge level. This is the appointment process defined in Article 233. This is where the High Court's critical constitutional check comes into play, isn't it?
It is. Formally, the appointment, posting, and promotion of district judges in a state are executed by the governor of that state. On the surface, this appears to be a clear executive function at the state level.
But the word formally is key here.
Yeah.
There's a crucial constitutional constraint attached to this executive power, ensuring judicial oversight. What does Article 233 mandate?
The governor must act only in consultation with the High Court of that state. This mandatory consultation is the constitutional bulwark designed to shield the judiciary from arbitrary executive interference. The High Court, being intimately familiar with the judicial personnel and legal requirements, provides the necessary judicial oversight to ensure suitability and legal merit are prioritized over political considerations.
Now let's transition from the literal text of consultation to the practical legal reality, which is often where high-level exam questions are focused. Has the Supreme Court defined what consultation actually means in this context, especially concerning the High Court's recommendation?
Oh, absolutely. The Supreme Court has repeatedly clarified this definition, moving its interpretation far beyond a simple exchange of views. Landmark cases, particularly those arising from Chandra v. State of UP and later judgments like State of Bihar v. Balnakunsa, have defined the scope of this consultation.
So what's the bottom line for a learner?
The critical insight is that the Supreme Court has ruled that the High Court's recommendation, especially regarding suitability and eligibility, must be given primacy. In effect, while the Constitution says consultation, judicial precedent has transformed it into functional concurrence.
So if the High Court recommends candidate A, and the governor or the state executive prefers candidate B, the executive cannot simply override the High Court's choice based on its administrative preference. Is that right?
That's exactly right. The recommendation of the High Court is virtually binding. This judicial interpretation of Article 233 is one of the strongest constitutional features ensuring the functional independence of the subordinate judiciary. If the executive had the final say, it would allow institutional capture and politicization of the district judiciary, undermining the entire integrated system.
Let's detail the specific qualifications a candidate must fulfill to be eligible for appointment as a district judge, as mandated by the source material. What are they?
The qualifications are quite rigorous, and they emphasize experience outside the government bureaucracy. First, the person must not already be in the service of the central or state government.
So they can't be a civil servant and just move over?
Correct. They must come from private legal practice or be serving in a subordinate judicial post, but they can't be holding any political or administrative office. Second, they must have been an advocate or a pleader for a minimum continuous period of 7 years. This ensures substantial and consistent legal practice.
And the third?
Third, and as we just discussed, they must be specifically recommended by the High Court for the appointment. This trio of requirements ensures independence, experience, and judicial endorsement.
Okay, that makes sense. Moving down the hierarchy from the district judge, what about the appointment process for judges who staff the courts below them, the civil judges and judicial magistrates? I believe the method changes slightly here, bringing in an extra layer of administrative consultation under Article 234.
It does. The appointment of persons other than district judges to the judicial service of a state is still formalized by the governor of the state, so the executive signature remains on the order.
But this process introduces a double consultation requirement, ensuring both bureaucratic efficiency and judicial suitability. What are these two consultative bodies, and what is their institutional purpose?
The governor must consult with two specific separate bodies, the State Public Service Commission, or SPSC, and the High Court. The dual nature of this consultation is highly deliberate.
Why both? What does each bring to the table?
Well, the involvement of the SPSC ensures that the recruitment process is merit-based, conducted through a standardized, competitive written examination and interview framework. So that satisfies the administrative requirement for fair public recruitment.
And the High Court.
The mandatory consultation with the High Court reinforces the judicial character of the selection. It ensures that even these entry-level personnel are suitable for judicial functions, that they understand the nuances of judicial temperament and ethics.
So the SPSC vets for general administrative competence and merit, while the High Court vets for judicial competence and suitability. But does this dual consultation ever lead to conflict? I mean, what if the SPSC rank list differs from the High Court's assessment of suitability?
That is a fascinating legal gray area and a common tension point in state administration. While the system is designed for checks and balances, friction can and does arise. Judicial precedent, however, generally holds that the High Court's recommendations regarding the list and suitability carry significant weight.
So the High Court's view would likely prevail?
Yes, it often overrides the administrative rankings of the SPSC, particularly if the High Court finds a candidate unsuitable for judicial office, even if they top the SPSC examination. This constant reinforcement of the High Court's final authority, enshrined in constitutional interpretation, is key to preventing the judicial service from becoming merely another part of the executive civil service. It elevates judicial independence right from the entry level.
We've established the constitutional anchor of the subordinate judiciary in Part 6. Now, let's look at where the system gets really interesting and, let's be honest, complex with the proliferation of specialized, parallel, and complementary mechanisms.
Yes, these were largely created through parliamentary acts. designed to handle the sheer volume and specialization of modern litigation, relieving the crushing burden on the traditional civil courts.
We're moving into the realm of tribunalization and alternative dispute resolution, ADR, which reflects the state's continuous attempt to find specialized and swift justice delivery outside the traditional, often very slow litigation path. This is a critical area for understanding judicial reform and governance efficacy.
Absolutely.
Let's start with administrative tribunals, specifically the state administrative tribunals, or SAPs, which deal with the service matters of millions of government employees. These were established under the Foundational Administrative Tribunals Act of 1985.
And that act itself was enabled by Article 323A of the Constitution, which was inserted via the 42nd Amendment. That constitutional basis is important because it allowed Parliament to legislate for the adjudication of disputes relating to recruitment and conditions of service of government personnel by tribunals, essentially taking these matters out of the purview of the traditional high courts at first.
At first, right. The 1985 Act then operationalized this by creating the Central Administrative Tribunal, CAT, and allowing for SATs upon state request. So the Act allows the central government to establish SATs, but with a clear nod to cooperative federalism.
Precisely. It allows for the creation of an SAT, but only upon the specific request of the concerned state government. This is a clear demonstration that while the structure is centrally provided, the operational implementation is state-driven based on need.
And their jurisdiction is highly focused. They operate with original jurisdiction, but only over service disputes.
Exactly. SATs and SATs exercise original jurisdiction exclusively related to recruitment and all service matters of state government employees, including seniority, pensions, and disciplinary actions. This specialization ensures that service law, which is often dense and administrative in nature, is handled by dedicated bodies, theoretically ensuring faster and more informed decisions than general civil courts could provide.
But the history of tribunals is complex, particularly concerning judicial review. For you preparing for the UPSC, understanding the evolution of judicial control over these bodies is absolutely essential. Didn't the original 1985 Act try to exclude the jurisdiction of high courts?
That's a crucial historical context. Section 28 of the original Administrative Tribunals Act did explicitly exclude the jurisdiction of all courts, except the Supreme Court, over these service matters. This was the peak of the tribunalization movement, intended to make tribunals autonomous and final.
But that didn't last.
It didn't. This structure was challenged and ultimately overturned by the Supreme Court in the landmark 1997 decision Chandra Kumar v. Union of India.
What was the core ruling of the Chandra Kumar case? What did it change?
The Supreme Court held that the power of judicial review of high courts under Articles 226 and 227 is part of the basic structure of the Constitution. Therefore, Parliament could not totally exclude the high court's jurisdiction over tribunals.
So it brought them back into the fold.
Exactly. The ruling mandated that all decisions of tribunals, including SATs, would be subject to the supervisory jurisdiction of the respective high courts. This completely shifted the paradigm, formally integrating tribunals back under the judicial hierarchy's appellate oversight.
Now let's examine the appointment mechanism for SAT members. Even though the SAT is solving administrative problems, its leadership must be anchored in judicial expertise, I assume.
Yes. The chairman and members of the SATs are appointed by the central government. However, this is not a purely political or executive appointment. It relies on the recommendations of a high-level search-cum-selection committee.
And who leads that committee?
Critically, this committee is chaired by the Chief Justice of the High Court of the concerned state, or a nominee of the Chief Justice.
That structural check is powerful. It ensures that even though the appointment is issued by the center, the screening process is overseen by the highest judicial authority in the state.
Absolutely. The Chief Justice's involvement is central to ensuring the mechanism's credibility, constitutional linkage, and functional independence. It guarantees that the individuals selected, whether they are judicial members from the retired judiciary or administrative members from the senior bureaucracy, possess the necessary legal temperament and expertise. The mix of judicial and administrative members is also a critical design feature, combining legal interpretation with practical administrative experience.
Okay, let's shift focus completely to the economy. The speed of commercial dispute resolution directly impacts foreign investment and the ease of doing business's ranking, which leads us to the establishment of commercial courts under the Commercial Courts Act 2015.
The rationale here is deeply pragmatic and economic. The government established these courts because the pace of justice delivery in high-stakes commercial matters was just too slow in traditional courts. Speedy disposal is necessary to provide a positive image to global and domestic investors regarding India's independent and responsive legal system.
And these cases are often more complex, right?
They are. High-value commercial disputes often involve complex financial facts and intricate questions of corporate law that demand specialized attention and faster procedures.
So how does the statutory system designed for speed integrate back into the existing judicial hierarchy?
It's integrated at multiple levels, depending on the dispute's value. The state government has the power to designate specialized commercial appellate courts at the district judge level. These courts specifically hear appeals originating from the commercial courts positioned below the district judge rank.
And what about the jurisdictional threshold, the pecuniary limit? This is critical for students to know.
The jurisdiction is determined by the specified value of the dispute. Initially, the threshold was quite high, but subsequent amendments have lowered it significantly to broaden accessibility. The Act now specifies that a commercial court has jurisdiction over commercial disputes where the value exceeds a certain defined minimum, which is currently set at 3 lakh rupees. This specific value delineation is what separates a regular civil suit from a commercial suit.
We must also look at the procedural innovations introduced to achieve that speed. I believe one of the most significant changes is the emphasis on mandatory alternative resolution before the formal trial begins.
That is a hallmark of the 2015 Act. For suits that do not seek urgent interim relief, the Act mandates pre-institution mediation and settlement, or PIMS, under Section 12A. A party must exhaust the PIMS mechanism before filing a suit in the commercial court.
So you can't just go straight to court.
Not unless you need an urgent order. This requirement is intended to encourage early, cost-effective resolution, preventing high-value commercial disputes from clogging the formal trial process unnecessarily. It reflects a systemic move toward efficiency.
And for those high courts that still maintain original civil jurisdiction, like Bombay, Madras, or Calcutta.
In those high courts, the Chief Justice may constitute a dedicated commercial division specifically to handle the specified high-value commercial disputes that would traditionally be filed directly in the High Court. This means the specialization exists at both the district and high court levels, ensuring that commercial matters are segregated from general litigation across the board.
Let's transition now to alternative dispute resolution, designed explicitly for speed, conciliation, and social accessibility. The Lok Adalats. These are often called the people's courts.
They are. Lok Adalats are judicial fora created to compromise and settle cases through conciliation, offering quick, affordable, and amicable justice, often referred to as justice without litigation. They handle a massive volume of pending cases and pre-litigation disputes, including matters under the Negotiable Instruments Act, bank recovery, and criminal compoundable matters.
The sources mention 3 types: national, state, and permanent Lok Adalats. The distinction here is crucial for understanding the state's commitment to service delivery.
The 2 main types are the periodic Lok Adalats, which are temporary bodies organized intermittently to clear backlogs, and the permanent Lok Adalats, or PLAs.
Why were the permanent Lok Adalats introduced later via the 2002 amendment to the Act? What was the need?
The Legal Services Authorities Act was amended in 2002 specifically to create permanent Lok Adalats to deal exclusively with disputes related to public utility services. This includes essential services like transport, postal, telegraph, electricity, water supply, and insurance.
And what's the key difference in how they operate?
The key difference is that PLAs are permanent bodies operating daily, whereas regular Lok Adalats are ad hoc. More importantly, if the parties fail to reach a settlement after conciliation, the PLA can proceed to decide the dispute on its merits, unlike a regular Lok Adalat, which must refer the case back to the trial court if no compromise is reached.
That power to decide rather than just conciliate is a huge difference. And once again, the composition links directly back to the formal judicial structure.
Indeed. To grant that decision-making power constitutional weight, the PLA requires a structured composition. The chairman must be or have been a district judge or an additional district judge, or have held a judicial office of higher rank than a district judge. This legal leadership is complemented by 2 other persons who must possess adequate experience in public utility services.
The explicit use of the district judge rank for leadership in permanent Lok Adalats really reinforces that theme we've been seeing, that the judicial structure's lower tiers are constantly adapted to solve specific, high-volume societal problems efficiently, utilizing personnel trained within the formal judicial system. It legitimizes the settlements and awards.
And a key legal detail. The award passed by a Lok Adalat, whether based on compromise or decided by a PLA, is deemed to be a decree of a civil court. It is final and binding on all parties and is not appealable in any court of law.
Not appealable.
No. This finality is crucial for achieving speedy resolution and preventing further litigation.
Finally, let's turn to the Consumer Protection Framework, modernized by the Consumer Protection Act 2019, which replaced the 1986 Act. This affects almost every commercial transaction in the country.
It does. The 2019 Act significantly streamlined and strengthened the consumer redressal mechanism. It established a clear three-tier machinery: the District Commission, the State Commission, and the National Commission, forming a specialized parallel quasi-judicial structure designed to be easily accessible to the average consumer.
What were the key institutional changes brought in by the 2019 Act compared to the old structure, particularly regarding regulatory oversight?
Well, one major change was the introduction of the Central Consumer Protection Authority, or CCPA, a regulatory body with powers to inquire, investigate, and launch prosecutions, something the old Act lacked. Crucially, the 2019 Act also updated the jurisdictional scope, including e-commerce transactions and enhancing the pecuniary jurisdiction of the three tiers to reflect modern costs.
So the amounts you can claim at each level have gone up.
Significantly.
Yeah.
The District Commission now typically handles claims up to a much higher amount than before.
And what about the administrative oversight within this three-tier system? How does the State Commission maintain control over the district commissions below it?
The State Commission performs crucial administrative oversight functions over the lower tier. This includes the explicit power to transfer complaints pending before one district commission to another within the state, either upon application or of its own motion, ensuring efficient case management. Furthermore, the State Commission maintains explicit administrative control over all the district commissions within its territorial jurisdiction, which includes matters of infrastructure and personnel management, reinforcing the hierarchy.
And the composition at the district level, the entry point for most consumers.
The District Commission consists of a president and at least two, but not more than a prescribed number of members who must possess specific qualifications of competence, integrity, and standing, often including legal expertise. This base level ensures accessibility and specialized focus at the ground level, handling the vast bulk of consumer complaints.
We've thoroughly explored the foundational constitutional courts and the specialized statutory tribunals and commissions. Now, let's tie the entire pyramid back together by looking at the role of the High Court, the state apex, and the critical ongoing constitutional relationship between the High Court and the subordinate judiciary.
The High Court sits atop the state judicial structure, acting as the ultimate court of appeal within the state. While the Supreme Court is the apex of the nation, the High Court is vested with the constitutional power to interpret the Constitution, ensure the rule of law, and act as the principal protector of fundamental rights within its jurisdiction.
And critically, under Article 235, the High Court is the explicit supervisor of virtually everything we just discussed under the traditional hierarchy, reinforcing the integrated nature of the system.
That's the key structural link. Article 235 vests the control over district courts and courts subordinate to them, including matters of posting, promotion, and the grant of leave in the High Court. This administrative control is vital to ensuring efficiency, consistency, and maintaining judicial standards in the lower tiers. It provides a necessary counterbalance to the state executive's control over resources and appointments under Article 233.
Let's explicitly address the tension inherent in the constitutional design. The governor appoints and pays, that's executive control, but the High Court controls the service, that's judicial control. How does the system manage this separation of powers in practice?
This tension is a constant feature of judicial administration in India. The power of the High Court under Article 235 is absolute regarding judicial discipline, transfers, and internal administration of the service. The executive cannot interfere with disciplinary action initiated by the High Court against a subordinate judicial officer. The landmark rulings, particularly after the Chandra decision, solidify that the High Court is the sole authority regarding the judicial supervision of the subordinate courts.
So it prevents political interference through things like punitive transfers.
Precisely. It prevents institutional capture by political forces who might otherwise use transfers or disciplinary actions as leverage against judges.
Let's revisit the institutional necessity for the High Court's input in appointments. Just to summarize the constitutional check mechanism that prevents political control, especially regarding Article 233's interpretation.
As we emphasized, while the governor formally issues the order under Article 233, judicial interpretation mandates that the governor must accept the High Court's recommendation. This essentially turns consultation into concurrence for district judge appointments. This critical function is the single most important constitutional mechanism that stops the process from being purely executive.
And if we look at the other services where the SPSC is involved under Article 234,
Even there, the High Court's veto power on suitability is highly protected. This constitutional design is not just about independence from the executive, it is about ensuring the system's integrity. The High Court, being insulated from direct political pressure, acts as the guardian of the subordinate judiciary's impartiality and capability. The whole system stands or falls on the robust exercise of this consultative and controlling power by the High Court.
finally, let's talk about a power that links the citizen directly to the High Court and the Supreme Court, which is the wider reach of judicial power through writs. This is a frequently examined area for anyone preparing for competitive exams, requiring a precise distinction between the powers granted by Article 32 and Article 226.
The power to issue the five classic prerogative writs habeas corpus, mandamus, quo warranto, prohibition, and certiorari is the quintessential safeguard of constitutional rights. The High Court's writ jurisdiction, established under Article 226, is concurrent with the Supreme Court's jurisdiction under Article 32. This means an aggrieved party whose fundamental rights are violated can move to either the High Court or the Supreme Court directly.
But the scope is drastically different, and this is the vital insight for you listening.
Yes. The critical distinction is that the High Court's writ jurisdiction under Article 226 is significantly wider than the Supreme Court's jurisdiction under Article 32. Article 32 is exclusively reserved for the enforcement of fundamental rights, that is, its constitutional mandate as the ultimate guarantor of those rights.
So Article 32 is a laser beam for fundamental rights, and the High Court's power under Article 226.
The High Court, under Article 226, can issue writs for the enforcement of fundamental rights and for any other purpose. This any other purpose is the key phrase. It allows the High Court to issue writs for the enforcement of ordinary legal rights, statutory rights, administrative directions, contractual issues, which constitutes the vast majority of citizen-state interaction outside of constitutional matters. This makes the High Court the practical avenue for legal redressal at the state level.
Furthermore, Article 32 itself is a fundamental right, meaning the Supreme Court cannot refuse to hear a petition if a fundamental right has been violated. Is the same true for Article 226?
No, and this is another crucial point for structural understanding. While the remedy under Article 32 is guaranteed fundamental right, the remedy under Article 226 is discretionary. A High Court may, in certain circumstances, refuse to exercise its writ jurisdiction. For instance, if the petitioner has an effective alternative remedy available through a tribunal or lower court.
Why the discretion?
This discretion is necessary because the High Court deals with the breach of ordinary legal rights, which constitutes the bulk of its work. It allows them to manage their caseload and direct litigants to the appropriate forum.
That structural distribution of power, the Supreme Court protecting the Constitution and fundamental rights universally under Article 32, and the High Court protecting all legal rights within the state under Article 226, and supervising the entire subordinate structure under Article 235, is essential to understanding India's judicial federalism and the accessibility of justice at the regional level.
It perfectly illustrates the concept of an integrated judiciary, where authority and oversight flow clearly from the top down, but where the broader power for legal redressal and institutional control is maintained regionally by the High Court, preventing the National Apex Court from becoming overburdened with ordinary legal disputes.
So what does this all mean for you, the learner preparing for the rigors of competitive examination? We've seen that India's judicial system is not just a simplistic hierarchy, but a complex, brilliantly unified structure. This structure runs from the High Court's binding control over judicial appointments under Article 233
to the administrative oversight of the judicial service under Article 235.
and extends all the way to modern specialized bodies like administrative tribunals, post-el Chandra Kumar, commercial courts with mandatory mediation, and the non-appealable nature of permanent Lok Adalats awards.
The primary takeaway here must be synthesis, moving beyond simply memorizing Articles 233 through 237. Understanding the institutional dynamics like the interpretation of consultation as concurrence, the role of the Chief Justice in tribunal selection, or the dual mandate of the SPSC and HC in lower appointments, is what ensures you grasp how the system maintains judicial independence and stability in governance.
It's the how and why, not just the what.
Exactly. These complex concepts, anchored in case law and constitutional function, are what you need to articulate clearly in any high-level mains answer.
Before we leave you with a final thought, I want to reiterate our thanks to every single one of our existing community members for your incredible support. Your paid memberships and active engagement help us dedicate the necessary time to create these thoroughly researched deep dives. We literally couldn't do it without you. A quick final reminder. Free notes covering this entire discussion, complete with practice PYQs for quick reinforcement, are available on our Telegram channel. For those who want to level up their preparation, premium notes with extra PYQs and detailed model mains answers for mains questions are accessible on our Discord channel for Legend YouTube members. Do join these communities to refine your preparation. Please hit that like button, subscribe, and share your valuable comments.
Now, for the provocative thought we leave you with, one that builds directly on our analysis of specialized mechanisms. If the foundational goal of the integrated judiciary is consistent, unified enforcement of law across all states, we are currently seeing an increasing proliferation of specialized, parallel, and complementary bodies like SATs, commercial courts, and Lok Adalats at the lower tiers.
All designed for speed.
All designed for speed and specialization. These bodies solve specific issues quickly. The question then becomes, what long-term impact might this persistent trend toward specialized, rapid resolution have on the perceived sanctity, authority, and workload distribution of the traditional district courts, which were originally the constitutional anchors of state-level justice?
So as justice becomes increasingly specialized, does the generalist district judge lose centrality in the system?
That's the question. It's a structure evolving right beneath our eyes, constantly adapting to the administrative and economic pressures of a billion-plus population. Something to chew on as you continue your study of judicial reform.
Thank you for joining us for the deep dive. We'll see you next time.